All right, let the record reflect the presence of both counsel for the state, counsel for the defense, and the defendant. I've been informed that the jury has reached a verdict. And are there any issues we need to take up before we bring the jury in?
No, Your Honor.
Okay, well, let's go ahead and bring in the jury.
Please stand for the jury.
All right, please be seated. And let the record reflect the presence of the jury, all counsel and the defendant. And ladies and gentlemen, I've just been handed, I haven't looked at it, I've just been handed a piece of paper. I've been informed that you've reached a verdict. Is that correct? Yes. Okay. Court security has handed me the verdict. It is legally filled out and signed, and I'm handing it to Madam Clerk to publish.
State of Florida versus Millie Humphreys. Case number 24 CF 1795. We, the jury, finds as follows as to count one of the information. The defendant is guilty of trafficking in fentanyl 28 grams or more. We, the jury, finds as follows as to count two of the information. The defendant is guilty of resisting an officer without violence. Dated November 5th, 2025, signed by foreperson.
Thank you. Does either side wish to poll the jury?
Yes, Your Honor.
All right. And Madam Clerk, would you please poll the jury?
Yes, ma'am. Mr. Berry, is this your verdict?
Yes.
Mr. Richmond, is this your verdict?
Yes.
Ms. Standaland, is this your verdict?
Yes.
Ms. Ratcliffe, is this your verdict?
Yes.
Mr. Hatfield, is this your verdict?
Yes.
Ms. Bretsky, is this your verdict?
Yes.
Thank you.
Madam Clerk. All right, ladies and gentlemen, I have one final instruction to read to you. Counsel, this is 4.2. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. And ladies and gentlemen, Florida law prohibits judges from commenting on a verdict in any way. What I am allowed to do is thank you for your service. Sincerely. Our justice system would not work if we did not have people who were willing to serve. Thank you all for your service. It is sincerely appreciated, and I am releasing you from your duties. Thank you.
Please stand for the jury.
All right, please be seated. And let the record reflect that the jurors have left the courtroom. and that the defendant and all counsel are present. And do we wish to proceed with sentencing today?
Yes, Your Honor.
Okay. Do you all need some time to get ready?
Your Honor, if we could have about 5 minutes.
Sure.
For the state at least.
Absolutely. So I'll just put the white noise on and y'all can take as much time as you need.
Thank you, Your Honor.
Sure.
Eight 683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
You've been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Cyclone Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by.
I'm Amanda Gaskin with Briar
I didn't mean to cut anybody short. Are you, do you need more time?
When I help a hero buy or
And
sell
has the
a home,
state
they
prepared a
receive
score
check from
sheet?
Homes for Heroes.
Okay.
Check out
Maybe
an NPR
if you wouldn't. Yes. Okay, great. I'm going to turn the white noise back on so y'all can talk about that.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestvew's Coney Islands burgers and hot dogs, then I encourage
Thank you.
to
And
join
I've just
us
been
for
handed
lunch. Monday through
the
Thursday
score
from 10
sheet.
a.m. till 3 p.m., Friday from 10 a.m. till 4.
Does either side need more time? I don't want to cut anybody short. Okay. I don't know if, I can't remember off the top of my head if there is a bond in this case.
No.
Okay, I know it had been revoked in previous cases, because there are several pending cases, but if there is a bond, let me just check. I don't know whether pretrial detention was granted in this case or not.
I think he may have had a bond, but he didn't bond out.
Okay. Bond will be revoked.
I do not show any bonds on this case.
Oh, okay.
He
Thank
didn't
you.
make- He didn't do a bond out.
Okay. If one was set, let me see what it was set.
The bond was set at $500,000.
Oh. Yes, I do see on the clerk's minutes sheet from August 1st, 2024, there was a stipulated bond totaling $550,000. That was, at that time, the counts were numbered differently. Possession of marijuana greater than 20 grams was count 1 at that time, and then resisting without violence was count 2, and then trafficking in fentanyl was count 3. So the bonds were set at $25,000 each on counts 1 and 2. That's the possession of marijuana and the resisting without violence, and then $500,000 on the trafficking charge. The state did not seek pretrial detention, so bond is revoked. Looks like there was a motion filed to modify or reduce bond, and let me just see if that ever was heard. I'm just trying to make sure I had the accurate amount. Okay. Does anyone need more time before we proceed?
No, Your Honor. No, Your Honor.
Okay. To the state, are you all filing an amended information, or is the resisting without violence, is that actually count, is going to remain count 3? On the information that is currently filed, the resisting charges count 3. But on the information that was sent back to the jury, that count 2 had been removed and it was renumbered to count 2.
Your Honor, I will amend the information and non-protunct it to today's date, and we'll have that done tomorrow morning. And I'll put resisting as the actual count 2 so that it'll line with the clerks if that would be sufficient.
Is the one, although that one was in evidence, isn't it?
Well, that would be, they have to file an information.
Okay. All right. So yes, if you could please do, well, let me make sure that's acceptable. Is that going to mess you up?
If you would like to accept it, that's okay.
Okay. All right. We will, well, let me ask the defense. Is there any issue with me calling the resisting, referring to it as count 2? I mean, technically it's count 3 right now.
No problem.
Okay. All right. And State, would you like to make an argument or recommendation regarding sentencing?
Yes, Your Honor, just briefly.
Okay.
Your Honor, the state recommends 30 years in the Department of Corrections. The amount of fentanyl was egregious. It was 66 grams. The highest count is 28 grams or more. This is more than twice that amount. Your Honor, the defendant's priors include a felony, leaving the scene of a crash with injuries, fleeing or attempt to elude, possession of a controlled substance, and possession of a firearm by a convicted felon, and then there are 4 various misdemeanors as well. For those reasons, Your Honor, the state would ask for 30 years in the Department of Corrections, and there is a mandatory $500,000 fine.
And what is the minimum mandatory sentence?
And the state will address count 2, the resisting without violence. That charge would be credit for time served.
Okay. And the minimum mandatory sentence on count 1, I believe, is 25 years?
Yes, Your Honor.
Okay. Thank you.
Your Honor, if I said cash or professional, could you strike that?
Oh, I didn't catch it if you did.
I might have said cash or professional, I just meant $500,000 fine.
If you did,
I was thinking of
I didn't
Okay.
catch that. You may have, and I missed that. I was busy taking notes on the amount. And has the defense reviewed the score sheet?
Yes, Your Honor.
Are there any objections or corrections to the score sheet?
No, Your Honor.
Okay. The score sheet shows 103.4 total sentence points. And would of course, Ms. Dudley, I'm going to give you a chance to make argument. Would Mr. Humphreys like to say anything either now or after you finish your argument?
No, yeah.
Okay. And whenever you're ready, Ms. Dudley.
And I would just ask that he not be given more than the minimum mandatory. He's 25 years old. 25 years, man, is a lot in general. But I would ask that he not be given more than the 25-year minimum mandatory that is required by law. Time served on a misdemeanor. And while he does have criminal history, he does not have a huge amount of criminal history. I think most of them came from two cases. I would just ask that the court consider that as age and not give him more than 25 years that's required.
Thank you. And sir, I'm just going to give you another opportunity if there's anything you wish to say. Okay, thank you. First of all, there will be an adjudication of guilt on both charges, both the trafficking in fentanyl, 28 grams or more, and also the resisting an officer without violence. The jury did find the defendant guilty of both, and there will be an adjudication of guilt. So I have the statute printed out, and by that I mean 893.135, that's the trafficking statute. And I have reviewed the statute previously, and I'm reviewing it now. In the portion of the statute that deals with fentanyl trafficking, there are 3 increments of weight. The first one is 4 grams or more, but less than 14 grams. And there's a minimum mandatory sentence for that and a mandatory fine. Then the next level is 14 grams or more, but less than 28 grams. And then there's a minimum mandatory prison sentence for that, and also a minimum mandatory fine. Then the third category is 28 grams or more. And then the minimum mandatory prison sentence for that charge is 25 years. And there's a mandatory fine of $500,000. The statute does not break it down any further than that. Over 28 grams. It just says 28 grams or more. And in this case, the evidence supported a finding of 66 grams of fentanyl, which is more than double the third level of weight in the statute. As to the charge of trafficking in fentanyl 28 grams or more, the court finds that fentanyl is a scourge on our community. And the defendant has been found guilty by the jury of trafficking in an amount that is more than double the third threshold of weights in the statute. This is a first-degree felony. The maximum penalty is 30 years. The court is required to impose a minimum sentence of 25 years state prison. The court finds in this case, based upon the evidence that came out during the trial and a review of the defendant's criminal history, which is not as lengthy as some, but it's not non-existent either. The court does find that 30 years is an appropriate sentence, and that's what the sentence will be. 30 years state prison, 25 years of which is a mandatory minimum sentence. And the court is imposing a $500,000 fine, which is a mandatory fine, plus a mandatory 5% surcharge, plus $515 in court costs. As to the charge of resisting an officer without violence, the court will sentence the defendant to 11 months and 29 days in the county jail, concurrent with the trafficking charge, and the defendant will receive credit for time served on both counts. And I know that Mr. Humphreys has a significant amount of credit. The jail will determine how much it is exactly, but I believe he probably has more credit than the sentence on the misdemeanor charge anyway. Are there any other findings the court needs to make or details that I need to cover?
Is there an amount of time to pay?
Will this be reduced to a lien?
Yes, sir.
Okay, let's reduce that, all the financials to a lien. And sir, you'll have 30 days to appeal the judgment and sentence of the court. If you cannot afford a lawyer, I'll appoint one for you. Good luck to you, sir. Thank you. And we're adjourned. Thank you.